Hello, everyone. This is Nina Olson, the Executive Director for the Center for Taxpayer Rights, and we are here today welcoming you to the webinar Representing Domestic Violence Survivors in IRS Disputes, Part 2. Now, before we start the program and as people are joining, I'm going to give you some housekeeping information. First of all, if you are seeking continuing legal education credit, you must attend the entire program. Partial credit is not available. During the program, a number of polling questions will appear, and so you need to respond to each polling question on the screen to confirm your participation in the program. They're not complicated, but you do need to, respond to them in order to be able to get continuing legal education credit. 48 hours after the end of today's program, you will receive an email containing a link to your CLE affidavit and information on how to receive your certificate. Please complete the CLE affidavit, providing your bar information as requested. Once the completed form is submitted, your certificates will be emailed to you. So, DeMarcus, let's move to the next screen. Now, I want to just take a moment to introduce our panel. We actually have three really talented and knowledgeable panelists today. Leslie Allen from Philadelphia Legal Aid, Audrey Patton from the Legal Services Center of Harvard Law School, and Christine Spidel from Villanova Federal Tax Clinic. And Audrey and Christine have just finished authoring and updating the ABA tax section's guide to innocent spouse relief. And at the end of our program, we will be showing on the screen a discount code for people who may want to order that guide and can get a discount. It's a terrific document. I've read it through, and I think anybody practicing in this area will find it enormously helpful. So just to kind of set up what we're going to do with this panel, we remember that this is part 2 of a series, and there will actually be a part 3. The first part was dealing with representing taxpayers before the IRS in disputes, domestic violence survivors in disputes with regarding child tax benefits, the earned income credit, marital status, where the ex-spouse has filed a married filing joint return and it's an invalid return. They may have claimed children to which they're not entitled to claim, eligible to claim, and working through the requirements of the different benefits provisions that are in the code that deal with family and also the working poor. This panel today is really dealing with the consequences of joint and several liability when you file a married filing joint return. And we will be setting this up with Leslie talking about some concerns that you may have as you're trying to deal with represent a survivor of domestic violence, and some of the issues that you should keep in mind as you're actually interviewing them on very sensitive issues, because these issues are actually often central to be able to getting relief from joint and several liability. And then we'll follow up with Audrey and Christine talking about Section 6015, which is the relief from joint and several liability, AKA innocent spouse statute in the code. And then, like our last video, we have a case study that is complex because life in all its fullness is very complex, and we'll be working through how you would interview, what you need to draw out, how do you deal with some facts that might complicate matters as you're dealing with the IRS and trying to get an IRS determination for innocent spouse relief. And we will end the program with the IRS's determination, which will lead us to part 3, which is bringing an innocent spouse case, a 6015 case, in tax court and the considerations of that. So I think right now we'll move to the next slide and turn to Leslie. Thank you.
Hello, everyone. I'm Leslie Allen, a supervising attorney of the Family Law Unit at Philadelphia Legal Assistance. We represent survivors of intimate partner violence in their domestic relations matters. Now, part 1 of this series provided an overview of IPV dynamics, the prevalence of IPV in the general population, and an understanding of the complexities of leaving. All of that information is still relevant today. So if you missed part one, I encourage you to go back and watch part one, which is available in the slide deck and online. I also wanted to let you know that I'm providing a 30,000-foot overview of IPV interviewing, trauma, and domestic violence screening methods. I'm going to do that in about 10 minutes. Now, these topics are actually very complex, and they could easily be a half day's worth of training and teaching. So if you would like any additional information or resources, please feel free to reach out to me. Next slide. All right. When you are conducting an interview of a client where you suspect that there is intimate partner violence, you want to have first a screening method that is able to pick up on intimate partner violence, even when the client does not use that term or currently identify as a survivor of intimate partner violence. Second, you want a method that's going to capture the context and extent of intimate partner violence. And third, you will need a plan to describe the effects of the accumulation of the abuser's actions on the survivor and the entire way that they've structured their lives. So I want to put everyone on alert that to do this, you're going to have to do an extensive interview about the most intimate parts of someone's life. And that talking about intimate partner violence is extremely difficult for the survivor. And that some issues, some memories are going to be more painful than others for the survivor to discuss. So the interviewing process may be a little bit more complicated than the sort of interview that you're used to conducting. To put it in context, if a survivor was to start working with a therapist would never push them to tell their entire trauma narrative in a first session all at once, because it can be re-traumatizing and emotionally dangerous. But our job as a survivor's lawyer often puts us in a role where we are going to be asking for information that causes a great deal of pain. So there are a few techniques that you can use to sort of set up the interview in a way that is safer for the client. First, you should flag how long you're going to be able to talk to them. If there's a hard stop later that you have another appointment to get through, so that you're not abruptly interrupting their story. You should also make sure that they have enough time to have this sort of discussion. And second, you should give an overview of what kind of questions you're going to ask and flag that it might cause them to have a very strong emotional response. Third, you should tell them that they have the ability to stop the question at any time or to request to skip a question. This particularly comes up if you start to ask about sexual violence. They just might not be ready to have that conversation with you right now. And they should know that they ultimately are the people who are in control of how this discussion is going to go. Fourth, if a client is having a very strong emotional reaction, they're crying or hyperventilating or potentially disassociating and start to just seem like they're really spaced out and far away, then you want to maybe give them the chance to have a break, drink some water, do some deep breathing, and maybe give them the option to sort of spend time alone at home reflecting on some of these questions, writing out a timeline, collecting their thoughts, rather than having to go through this whole history face to face with you, which might really bring up some strong reactions. And then finally, it's really important that you remind them that everything that you discuss is confidential. And that while you may be aiming to use some of these disclosures in something you might file with court and tell their abuser, that you're going to review whatever you're going to file with them in advance and make sure that they feel comfortable making those disclosures. And of course, sometimes this might mean that you might think that you have a really, really strong fact, particularly for a sexual violence issue, and you may think that that's essential to winning your case, but still ultimately it's the survivor's choice if they want to put that in the filing. Next slide. So this is the empirically tested and extensively written about HITS plus screening tool. And it is just a 5-question screening tool that you could put in your intake materials that sort of helps you know if you have an IPV case in order to do a more extensive interview. And this tool is very simple. It's using the never, rarely, sometimes, often, and frequently standard, scoring rarely, sometimes, often, and frequently as 1, 2, 3, and 4. And the questions are, has your intimate partner ever physically hurt you? Have they ever talked down or insulted you? Have they ever threatened you with harm? Have they ever screamed or cursed at you? Or have they ever forced you to do sexual acts that you are not comfortable with? What's really useful about this screening tool is it's fast, it's effective, and it also is going to help you capture cases where someone, maybe because there wasn't that much physical violence, does not immediately identify as a survivor of intimate partner violence, but actually there's this intense coercive control dynamic. Next slide. All right, so I want to talk a little bit about why we might want to use this more detailed screening method that I'm going to be discussing. A screening guide is incredibly helpful because survivors often have not put together the totality of violence and coercive control into a narrative that makes sense from an outsider's perspective. They may often speak in generalizations or omit really relevant facts. Sometimes you'll hear things like, sometimes we fought and it got physical. And then when you try to pull on that, the client can be sort of resistant to adding more detail. But these tools help you break down those generalizations and help you find that story of escalating violence embedded in a pattern of control. They're also helpful because the effects of trauma are such that survivors' minds are self-protective, and that these painful memories are ones that they've been trying not to think about, or probably actively denying throughout the relationship or even really happening. And so there's going to be, when you're doing these interviews, you're going to notice that there's going to be difficulty in sequencing events and possibly fixation on some minor details and omissions of highly relevant details. And so these screening tools help make sure that you're covering sort of the totality of the general experience and getting out those really key facts. Further, because of the details were a secret for so long for the survivor, they may not have even processed some of these details as relevant to the intimate partner violence dynamic that they're describing. Next slide. So I circulated with the materials the safer method for domestic violence screening from the Battered Women's Justice Project. There are other tools that are relatively similar, but I find that this tool is particularly excellent because it has so much variety in it. We don't really have time to go through the entire tool, but I did want to just draw attention to this checklist to sort of flag some of the advantages of using an actual screening method when you're interviewing a domestic violence survivor. If you read through these checklists, you'll see that some of these questions might not be obviously part of the domestic violence control dynamic that exists, but are really relevant details to add into a story of IPV. Ones that I want to flag are withholding medicine, disabling medical equipment, interfering with someone's sleep, driving recklessly in order to scare the survivor and make them feel that their life is at risk, forbidding the survivor from leaving the house, or creating harsh consequences if they are to leave without announcing where they're going. Shutting off utilities, especially if the shutoff is connected to some kind of a punishment. Refusal to let the survivor work, or a demand that the survivor immediately turn over any money earned at work to the abuser. And using spies to watch and monitor the survivor. These kind of details often get left out when someone is just asked to tell their story of IPV, and yet they can really help make the narrative come to life to help understand what the impact of the violence was and why this was such a defining and controlling relationship. And then once you start to get yeses on any of these questions, you can have the client break down the frequency of how often these behaviors happened, the timeline, when did this happen, for how many years was it happening, and lastly, what impact this was having on the client. Next slide. So last, what I want to talk about very briefly is how to help then prepare your client for the next steps in a way that maintains their own safety. So safety planning in the IPV context is definitely something that people can receive extensive training on, and domestic violence advocates are particularly well suited to be providing. However, there is some safety planning that I believe that an attorney should be giving to their litigants. And first, that is really what's relevant to the litigation. Clients know their abusers best, and talking to your client about what their abuser might do after they read a filing in court or find out that litigation has begun is very important in mitigating what the abuser's reaction might be. A client can give you sort of a spread of what they think the most severe reaction could be to the more minor. And then together you can brainstorm what actions the survivor can take to sort of mitigate the harm, acknowledging that it's almost impossible to totally protect the survivor. It can be creative and it should be very individually tailored. There's also this issue that I see come up in the cases where there's large financial stakes, which is that the survivor may be then pursued by the abuser to reconcile in order to make the legal case resolve in the abuser's favor. Letting the survivor know that this is a pattern that you anticipate and see can help reduce the likelihood of it happening. Or even if it does happen, you're then signaling to the survivor that the survivor should tell you if this is something that is occurring, and that you should flag for them that the abuser may ask them to recant their story, to sign a document saying that the allegations are not true and that they made them up, or to even go on video making statements disproving their case. So this is both something that we see happen, but also a way to sort of safety plan against this harm. And then lastly, it's wise to brainstorm with your client about how they can increase their safety once litigation starts, making sure that they've changed all their passwords, considering the installation of home security devices, and making sure that if they have shared children, that there is a plan in place to make sure that the survivor is maintaining access to their children during the course of litigation is really smart. Because once you start litigation, there could be a reaction, maybe actually in the court that you're practicing in, but there could be additional filings in civil court for child custody cases. There could be false criminal complaints made, and the survivor really needs to be on notice about how to best protect themselves once some of these secrets start to be made public. All right, and thank you. I'm going to hand off this to a poll question now.
Okay, I think we're going to have a poll question now, and while that's going, a couple of people have said on the Q&A that they haven't received their certification, CLE certificate from part 1, so we'll look into that. And I will also note that a recording of part 1 and this program will be on the ABA website and will also be on the LITC Support Center website. So it looks like we've got all the answers to that question, I think, or most of them. Wait a little bit longer, then we can go to the next section. Christine, do you want to start?
Yes, thank you. I'm Christine Spidel, and I direct the Federal Tax Clinic at Villanova University Law School. So we're going to segue now into talking about innocent spouse relief. But the first thing I want to talk about is why we have innocent spouse relief. What is it and why do we have it? We could go to the next slide, please. Great. So we have innocent spouse relief because of joint and several liability for married couples who file joint tax returns. We didn't always have joint filing for married couples in this country, and many other countries do not have joint filing. They have individual tax responsibilities, but in the United States, for a variety of reasons, for many, many years, we have now had a practice of most married couples, over 90%, filing joint tax returns. And there are many reasons for doing this that Congress has written into the code. There are penalties for filing separately, certain credits that you cannot get if you file separately from your spouse in some situations. So over the years, we've sort of developed, I think, sort of a common perception that it's just what married people do. And we have clients who are not aware that there's another option or are not aware that they are affirmatively making an election to file jointly every single year that they decide to do that. So it's under the tax law, it's not the default, but it is practically speaking the default for most tax preparers and for most taxpayers, most people, because it's usually the most financially advantageous way to file if everything is well and good between the spouses. But the downside to filing your taxes jointly is that the law creates joint and several liability for all tax owed on the return that's reported on the return, no matter who earns the income, and for all tax that liability that sort of flows from the return or that arises from the return that's assessed later. So I'm going to go through an example on the next slide. This is a fact pattern that we see pretty often, big disparity in income between spouses. You might have one spouse that's primarily a homemaker or just getting back into the workforce, earning a low wage as a cashier, a restaurant worker, and spouse number two earns a significantly higher income and is also self-employed or has a business. If those spouses file jointly, see one spouse earns $10,000 a year, the other spouse earns $80,000 a year. There's a big difference in tax liability if they were to file individually. They file jointly because maybe they want to get an education credit or other tax benefits. And they can also offset the tax owed by spouse two by including spouse one and any children on a joint return. So if these spouses file jointly and owe a balance, joint and several liability means the IRS can collect the full balance from either spouse. They can only collect it once, but they can go after whoever they choose, and both spouses are liable for 100% of the tax owed on that $90,000 joint income. If the IRS later audits this couple, they see spouse two claimed a home office and claimed mileage. If spouse two didn't keep very good records, the IRS comes in and audits, disallows their business expenses and says, actually, you owe us $30,000 more from your business. That is a joint liability also, even if spouse one had no involvement in the business, had no knowledge that the deductions were improper, spouse one is on the hook for that additional $30,000 because of joint and several liability for filing a joint tax return. So the IRS being concerned with efficiency and under-resourced, the IRS is going to collect that money from the person it is easiest to collect from. And that's primarily done by the IRS computer system, the behemoth IRS collection machinery looking for sources to levy. And they will quickly find spouse one has that wage income, which is extremely easy for the IRS to garnish. They just have to send a letter to the employer and it's done. It's a lot harder to collect from somebody who's self-employed. So joint and several liability in a situation like this can create a lot of unfair situations and a lot of exposure to a spouse who maybe we might think should not equitably be subject to it. So let's go to the next slide. The solution to this dilemma that joint and several liability was leading to very sympathetic cases of usually the wife, usually the lower income partner being left on the hook for huge liabilities in unfair situations. The solution is innocent spouse relief, which is in the tax code under section 6015. And assuming that joint tax return was a valid joint return, the solution for spouse one suddenly being on the hook for this huge tax debt, the solution for her is to request innocent spouse relief under 6015. And I want to refer everyone to part one, the other webinar on the issue of when the return is not valid or when there was duress in the signing of that return. That was an extensive discussion in part one. So we're going to proceed today, assuming that was a valid joint return. I'm going to go through briefly a little bit of the law. Section 6015 has 3 types of relief. We'll probably spend the most time on equitable relief, section 6015F, but I do want to go through briefly all three. And also just note that, again, for administrative convenience, the IRS has put out a single application form. So when you are helping somebody apply, it's good to know the law and to plan for the different types of relief, but there is a single application that you will be submitting. And it doesn't even ask which types of relief you're seeking. So the first one is called traditional relief under 6015B. And if we could go to the next slide, got the factors there. This is called traditional relief because before 1998, there was this was in a different section of the code, but this had already existed for some time. Equitable relief is newer and was created in 1998. So the requirements for traditional innocent spouse relief are that the tax return didn't correctly reflect the liability. So you have to be in a situation where there was a later audit and the IRS decided the return was not correct. And the additional tax that the IRS imposes later has to be due to income or credits or deductions or something that was caused by the non-requesting spouse, the other spouse. You'll hear us use requesting spouse for the spouse that's asking for relief and non-requesting spouse for the other. The third, in signing the return, the requesting spouse can't have known or had reason to know that the tax on the return was wrong. So they can't have known that their spouse was leaving income off the return or overstating deduction. And fourth, considering all the facts and circumstances, it's inequitable to hold the requesting spouse liable for the deficiency in tax. And what that means, we'll talk about a little later when we talk about equitable relief, because the IRS generally applies the same test for what is equitable. So these also kind of conflate together. There's also a 2-year limit on requesting this type of relief from the first collection activity on that tax assessment. That 2-year limit also applies to the next type of relief, which we'll go through briefly on the next slide, which is separation of liability under 6015C. Within 2 years of the first collection activity, either spouse can elect to essentially separate the liability as if they had filed separately. And so this one does not require you to prove that it would be inequitable to hold you jointly liable. So this is kind of a nice option if you get to somebody early enough and they don't want to get into the details of the relationship. If you meet this criteria, your client does not have to disclose very much personal information, or relatively speaking, at least, to the other two. So again, this relief only applies to understatements of tax, meaning that the tax return that was filed was not correct, and the IRS later assessed additional tax. Similar to the first one, the understatement was due to items of the non-requesting spouse. And at the time the election is made, the requesting spouse is either no longer married to the other spouse or is legally separated, or has not been a member of the same household for at least 12 months. Legal separation is a term of art. Not all states have legal separation, so be careful of that. You want to definitely make sure that, for example, you would never ask a client, are you legally separated? Because they will say yes, even if their state does not have legal separation. So we typically see the separated for at least 12 months and counting down to that date of eligibility to elect this. There is a knowledge factor here, but the burden is on the IRS, unlike the other 6015B. So relief is not available if the IRS demonstrates that the requesting spouse had actual knowledge of the item that caused the extra tax to be owed. So you had actual knowledge that your spouse was embezzling, for example. If the IRS can prove that, you had a joint bank account, or you had been present when they were indicted or been present when they were arrested for embezzlement. If you have actual knowledge of the income that was left off the return, then you're not eligible for separation of liability if the IRS can prove that. And then the third and the one that we'll focus on the most, the third type of innocent spouse relief is under 6015F. On the next slide, we have the criteria for equitable release. And you can see it's that first bullet point. It's extremely broad in the statute. Considering all relevant facts and circumstances, it is inequitable to hold the requesting spouse liable for either the deficiency in tax or for an amount that's unpaid. So this is the only type of relief that you can request if the tax return was completely correct. It just reported a balance due that was never paid. You're going to be requesting equitable relief because the first two types only apply when the IRS comes in later and says you left something off the return. And the 2-year limit that applies to the first two types does not apply to equitable relief. You can ask for relief anytime that you owe the liability or anytime that you're within the time frame to ask for a refund if your client has made payments on the liability. There are some regulations under Section 6015 that are a little bit outdated. There is also non-regulatory guidance. Revenue Procedure 2013-34 is the current version of guidance that sort of sets out the IRS view on what facts and circumstances are generally going to be relevant. And I think the next slide has a list of those. So Revenue Procedure 2013-34 is a must read. If you are helping somebody through this process, you want to read it and thoroughly understand it. It has certain threshold criteria that it sets out the IRS will go through. And it also sets out some factors that the IRS will always look at when it's deciding whether your client is entitled to equitable relief. And these are non-exclusive factors. Remember, the statutory language is extremely broad. And so as advocates, we can craft our client's story and we can propose additional factors that we think are relevant. And you'll notice abuse is not on this list of factors. Abuse is something, as Audrey will talk about in a minute, that can influence these other factors. So it is extremely important to your client's narrative of why, considering all the facts and circumstances of their situation, they should not have to pay this liability caused by their ex. But that is the ultimate question to kind of keep in your mind, even if you're going through the details. After you go through the details and build up your case on each factor, you want to bring it all back to the big picture story and the actual legal test in the law, which is extremely broad. So the IRS will look to these factors. They are not binding on the tax court, but the tax court, if you end up in tax court, does generally look at these, although it's not required to follow the revenue procedure. Let's see. Let's move on to the next slide. And I'll turn it over to Audrey to talk a little bit more about the role of abuse.
And I think at this point, we were going to have a polling question. Yeah, while Audrey's chatting.
Okay. Well, hi, everyone. I'm Audrey Patton from the tax clinic, the low-income taxpayer clinic at Harvard Law School. Picking off with what Christine was just talking about with those equitable relief factors, when you're thinking about a client's potential for innocent spouse relief, particularly a client that may have experienced abuse or intimate partner violence, you always want to have those factors in mind and be building your story around them. And that's in part because even if you think your client may be a shoo-in for B or C relief, the IRS may not agree with that, and they're going to keep reviewing the application until they get to F relief. So it's best to be prepared with the most comprehensive story you can have going in. Christine talked about something very important, that F relief is equitable relief. There are very few places, in fact, I can only think of 2 or 3 in the entire Internal Revenue Code that talk specifically about equity. Fairness factors, balancing the totality of the circumstances. Most issues in tax are not weighed that way. And so that's very important to keep in mind too, because you are trying to tailor your story to this individual person's situation. So as you go through these factors, they're not just a checklist. You want to be thinking about how they interplay with each other to present your client's most compelling narrative. And part of that, if abuse is present in your client's relationship with their non-requesting spouse, we need to think about, why did that matter? And why did that make it, does it make it unfair to hold this person liable for the joint returns? It's important to say up front that the presence of abuse by itself is not dispositive. It's part of what's weighing that totality of the circumstances. On the converse, you're not required to present a narrative of abuse in order to receive innocent spouse relief. There are people in certain situations that may be entitled to relief where abuse just is not part of the story at all. The word abuse pops up, my last count, 8 different times in the revenue procedure that's used by the IRS to evaluate an innocent spouse application. Its most comprehensive definition falls under the part of the revenue procedure that talks about knowledge, but it is not limited to evaluating or mitigating the knowledge factor. And it's a lengthy definition, but I think it's important actually to go through it, to read it. It's, abuse comes in many forms and can include physical, psychological, sexual, or emotional abuse, including efforts to control, isolate, humiliate, and intimidate the requesting spouse, or to undermine the requesting spouse's ability to reason independently and be able to do what is required under the tax laws. And then, of course, it talks about facts and circumstances, and then even goes so far as to mention the non-requesting spouse's alcohol or drug abuse. This definition or this explanation of abuse should not be looked at as just a bunch of words saying the same thing, because it's not. Something that is, in my view, quite extraordinary about this is that it's not limited to talking about physical violence or the threat of physical violence. It goes beyond that. Now, this matters because when you're meeting a client, they may be conditioned to talking about abuse as being linked to violence, particularly if they have gone through some sort of state law processes. In a lot of states, for example, in Massachusetts, where I practice, you can't get a restraining order unless you're proving the presence of physical violence or the threat of physical violence. All right, so that is definitely something to think about when you look at this. It's expansive also in that, it's talking here about prolonged emotional abuse, right? Is this person, and this is what you want to think about when building their story, is this person so, put down in the relationship that it's just too much effort to be able to talk about the tax returns or question the tax returns? Is this somebody who has to go through and pick their battles throughout their daily life to avoid negative consequences? If this is a person that's coming to you and there's a history of other types of control, like isolation and humiliation, that is very important to think about and to bring up. And, as you go through that, you're of course also going to have to be thinking about documentation or evidence or eliciting testimony. I'll talk a little bit about that later. But again, the big takeaway here is abuse under this revenue procedure is not just about physical violence or the threat thereof. Could we go to the next slide, please? Another thing to consider too, though, is that not all liabilities are going to be eligible for relief. And that is true, again, even if there is the presence of abuse, we have to go through and look carefully at whether or not there are some threshold matters that can be satisfied here to show that the person may be entitled to relief. When you're dealing with the client, this can be very difficult. I've had clients, I think we've all had clients who maybe come in and say, I was treated very badly in my marriage. I had no control over the tax returns. But then we may find out that the item that caused the liability on the tax return is actually traceable to them. Maybe something that they were not reporting on the return. And in a lot of cases, this may result in having to say to somebody, innocent spouse relief is not the right path for you, because generally speaking, relief is only available for liabilities caused by items of the non-requesting spouse. Something to keep in mind, the term innocent spouse is not a statutory term. And a lot of people, when they hear it, attach a moral judgment to it. So you have to be very sensitive to that. If you have a client, especially one who has experienced abuse in their relationship, you don't want to just run up to them and say, you're not an innocent spouse. You want to explain to them carefully what some of these threshold conditions are. And if you're saying, look, the liability on this joint return is because you had a side business and you didn't include it on the joint return, and make sure to explain it in that technical way so that they don't feel it's just a moral judgment on them, that they didn't suffer enough, or that the abuse wasn't real, or that their spouse wasn't actually controlling. There are some exceptions to that rule. Again, rules having to do with community property law and nominal ownership. If someone put something, in your name, I mean, that could be part of the control that they had over the client. Misappropriation of funds, abuse. Again, it is on here, but if you're going to argue that an item attributable to the requesting spouse someone should still be granted innocent spouse status in that case. There are some more specific language around abuse as to whether or not that will count. It's not just a holistic presentation of a narrative. And then, of course, fraud committed by the non-requesting spouse. As Christine said, the revenue procedure is not binding on the tax court. In practice, again, the strongest cases are set up both when you go to the agency, to the IRS, if they're built around the revenue procedure. And then if you've already got it set up that way in practice, that's going to be your strongest arguments in the tax court. But again, if you have special circumstances there, if you have factors that are not in the list of what we call the F factors, you should not feel limited. You should do research on what the tax court itself has said over different types of circumstances and present it. Can we do the next slide, please? It is beyond the scope of this presentation to talk about all the different fora in which you can argue innocent spouse. The most common and the one that we'll be talking about here is what we call the standalone application. When you initiate an innocent spouse case, it is to fill out what's called a Form 8857. It's a form created by the IRS. It has a lot of short questions on it and a lot of check boxes. And so you can find yourself in a situation where I have this person has come to me with this complex story. How do I fit it into all these short questions and these check boxes? So you want to think carefully about, accompanying that with an advocacy letter, narrative statements by your client, and documentary exhibits to back up what you say. You're not limited by the form. That being said, you have to complete the form in its entirety. And your client is signing that under pains and penalties of perjury, including a financial statement on the form. This is something too that can maybe frighten clients, especially if they're trying to put together a narrative statement that might include memories that are fuzzy, or they're not exactly sure what date an incident happened. So you want to go through the process of really fleshing out with your client to the best that you can what their story is. And in cases where it's limited, just like you would in any other affidavit that you're preparing, make sure that it's still vague enough that you're not setting up your client for accusations of perjury, but where they're also feeling free to get that story across and explain it. When the application is put together, in these standalone cases, you start off by sending them to the Cincinnati Centralized Innocent Spouse Operations. What will happen is an examiner at some point will get the application, they'll get the form, they will get whatever narrative you submitted, whatever letter you put together as the attorney, and exhibits. It's a documentation-based process. And that has its limits. Especially, again, if you're trying to talk about incidents that occurred in a marriage. It's one thing to have a theoretical example and know that, okay, somebody maybe they were beaten when they challenged the return, but you've really got to think about, how can I construct a narrative when there is not often documentation to back this up? Something to bear in mind. If you later go into the tax court, that file that is created at the IRS is the file, is the information that's going to be the administrative record for the tax court case. And you're not going to be able to introduce new evidence unless it's something that was not, discoverable at the time that you applied through Form 8857. So you want to get in as much as you can. If you have documentation, whether it's a medical report or something from a school counselor that your client is comfortable sharing, you want to get it in with this application, or send it as a follow-up addendum if it's not there with the initial submission that you put in. If at the examiner level in the innocent spouse operation, if they don't agree and they say your client is not entitled to innocent spouse relief, you'll get what's called a preliminary determination letter. You can then use that letter to fill out a form, I believe 123509, that will allow you to do an appeal to the Independent Office of Appeals to get a higher level of review. When it goes up to the Independent Office of Appeals, again, they're going to be looking at the file that was already submitted at the examiner level. You should get another opportunity to submit more documents, and you should get the opportunity to have a hearing to discuss your case. In practice, these are telephone hearings. So again, in the practical realities of these are very much going to be centered on documentation. And then again, this goes beyond the scope of the immediate presentation. If you then receive a final determination denying you relief, you have 90 days to petition the tax court. So that's how we go from the agency over to a new independent review in the tax court. Can we do the next slide, please? Okay. All right, so documentation. What can we do here? It's going to be different for every case that comes through, okay, obviously. But since this program is very much tailored to thinking about, again, proving narratives of abuse or control or domestic violence in a relationship, one of the first things to think about, are there any parallel court cases going on? Please don't, be siloed as the tax lawyer. Someone's coming in with a story and you're only thinking in terms of tax, because, I've seen clients come in where a single incident of domestic abuse can generate 5 different court cases at the same time. I've had clients that they come in, they have a family court case with a divorce now, they have a district court restraining order case, a juvenile case over maybe custody if the state got involved because of allegations of abuse, a criminal case against, where their spouse is being prosecuted, and tax problems. And to have a client come in and expect to have all of that organized and know what is going on in every single one of those cases at the same time is impossible. And so if you're advocating for them, in this case, perhaps in a tax matter, it's good practice to reach out and figure out what is going on in any other parallel cases related to this. And that's important for several reasons. One, you'll put together a better story. You'll be able to tie in a better narrative of what's going on in this person's life. Two, you might get access to documentation that really helps you. So, copies of restraining orders, copies of family court findings or temporary orders around abuse. Those things are all fair game to pull into your innocent spouse case, and not just on the issue of abuse, but on those other factors as well. Has there been a finding of legal obligation in the family court that one spouse admits that they caused the tax liability and they're going to pay it off? While that's not binding on the IRS, it's good evidence to submit in your case. Where available, medical records showing abuse, mental or physical illness, to the extent that your client is comfortable sharing these things. Police reports. Police reports, by the way, I've had examiners at the IRS ask me for police reports when there were already restraining orders in a file, and I've pointed out that police reports tend to be hearsay. But if you have them, great. I would not limit, though, your arguments about what may or may not have happened in a case just because you don't have your hands on that, or because they don't exist. Proof of clients' income and assets, are their own business expenses in order? That may be important too. I mean, you may be dealing with someone, again, where you're very focused on one part of their narrative, but remember the IRS has to look at this whole totality of circumstances. And the same thing with family records. If there are dependents involved, you want to show that, the relationships are provable. Custody documents, again, if there's a parallel family court matter, may be very useful in illustrating out the client's life and responsibilities. For example, saying a client who, they're currently struggling with economic hardship, they have dependents, they're the ones that another court has deemed to be the appropriate legal custodian of the children. These things all might play into the narrative and play a part. Okay, have the next slide, please. With innocent spouse cases, while on one hand, each individual tax year is what you are talking about being at issue. So let's say there is a joint return from 2017. Of course, events that may have happened in the year of that return are extremely important, but you also want to look at long-term patterns in a relationship. I've had clients that, they may be talking about one specific tax year and an incident of abuse was documented in a different tax year, but it helped beef up that client's narrative that this was happening repeatedly. And this created a situation in which, to avoid it happening again, I couldn't talk to my spouse about problems on the return. So you want to be really thinking holistically about the story. And find a way to, in presenting that narrative, again, through your client's own maybe signed affidavit and your own advocacy letter, talk about the style of the communication. Are you, again, you're not going to be able to prove necessarily every single thing that the client is testifying to or explaining, but you want to get across what the atmosphere was in the relationship, what the patterns were. At the same time, if there were any big watershed incidents to describe, you want to be able to do that in the most detail possible, right? If there was, again, an incident that escalated to the point of police involvement or a court case, the more detail you have, the better. And you want to know, too, from your client, what their perception was of their own financial involvement with the non-requesting spouse. It's okay to ask, well, why did you file joint returns? Did you understand you were filing joint returns? And what other stressors were present to maybe make it so that you didn't want to argue about the returns, or you felt you couldn't? And in doing that and really speaking to the client about these things, you want to be prepared for any inconsistencies. Again, these are conversations with a client where you're talking about the most intimate side of their life, their marriage. And most people, when they have a tax problem, it's not the first thing they think of to say, oh, I got to go to a lawyer and talk about all the personal details of that marriage. So that's something on the empathy side to really keep in mind. And because of that, though, you may find when you're talking to people that they have trouble pulling their story together. And so you want to be very careful with them and sit down with them and go through it and say, okay, but maybe these dates don't line up. Can you help me understand why? Or this happened, but it was 3 years before the tax return at issue. How do you think it affected it? And really get that person to help you connect the dots and help them build a strong narrative. I would say just my final point on these issues is don't be dismissive of somebody just because on the surface they come in and say, oh, I signed joint returns, but I felt I had no choice. You want to really flesh out why, and anything that you can't prove through documentation, work on building a signed narrative that you can prove, if not through the administrative process, but then later through testimony in the tax court. All right, and I think it's ready for another polling question before
No,
next
not
section.
yet. We're gonna go to the
Okay.
case study right now. And I just asked the panelists to keep their chat open so that they can see questions from the audience. You can use the chat feature rather than the Q&A, and also so that they can see communications among ourselves. So what we're gonna do is do a case study that will flesh out some of the things that we've covered so far, and we'll use the rest of the time to do the case study, and we'll be applying some of these issues and tools that we've covered so far in the course of the case study. So let's go to the next slide. I'm just going to read it, and then we're going to throw it out to the panelists to discuss some of these things. And this is an evolving case study because it sort of follows how you might be learning about the facts. So W has been married to H for 7 years, during which time she gave birth to 2 children. Until a year ago, she stayed at home with the children while H was self-employed and ran a delivery business. Although their checking account was a joint account, H controlled all the finances. H gave W an allowance from which she had to buy food and all the children's necessities. If she asked for anything over the allowance, H belittled her and railed at her for being incompetent, lazy, and greedy and spending all his money. He would loom over her, shake his fist at her, frightening her so much she learned to stop asking. If the children cried, he would rage at her for being a terrible mother. So one thing I thought, just in the facts so far, is, what elements of abuse are present, and also, does shaking a fist constitute abuse? I did have the experience of one IRS innocent spouse reviewer saying, well, he didn't hit her, and so that's not abuse. Anyone want to take that? Leslie, Christine, Audrey?
Yes, absolutely. So specifically regarding is the shaking of the fist abuse, that gets back to what I was discussing about making sure that you're tying it back to the survivor's experience and how they're interpreting the actions, right? So in this fact pattern, you might not have a clear moment of violence, but if she can describe how all of these actions and points of control resulted in her completely just structuring her whole life into making sure that he stayed in a good mood because she was afraid of what was going to happen next, you could really strengthen how you're describing that threat from the shaking of the fist.
Right.
Yeah, I agree.
To the next slide, and anybody else want to comment on that? Okay, well, so go ahead. Were you going to say something?
Oh, I can save it for the next slide.
Yeah. H always handled the tax returns for the family. He never let W look at them, just telling her she wouldn't understand. If she asked any questions, he accused her of not trusting him, pushing her out of his office and slamming the door in her face. W learned to not ask questions and would just sign the returns without trying to look at them. She was afraid if she looked at him, it would trigger another round of anger. So how does this behavior relate to actual knowledge or reason to know of the family finances? We've covered that issue both in B and C relief, and it's also a factor in F relief, in all three of them, actually.
I think this goes back to what Leslie was just saying about contextualizing what happened. Often the IRS wants to ask specific questions about a narrow window of time. What did you know? What did you do in April of 2015 when you signed the tax return or when you gave your W-2s to your spouse? And you just have to, I usually go back to the beginning of the relationship with my client to really understand the whole context, because I think this is pretty common that you have some with folks who've been together for a long time, you've got a history and you've got patterns that developed for a reason, and you have to show that. And I think this is a great example of building that context, and knowledge can be defeated by the presence of abuse. You just have to build the picture and bring in the broad definition of abuse from the revenue procedure, and explain to the IRS why in the circumstance that your client was in, a reasonable person would not have been able to ask questions.
Right. Anyone else want to weigh in here on that one? Okay, well, let's go to the next slide. So this has got a lot of language, but like I say, we're building our fact pattern. So recently, W decided to start cutting hair, something she used to do before her marriage, in order to bring more funds into the household. This increased H's rage. He would have huge mood swings, and she suspected he was taking drugs, although she couldn't imagine where the money for that would come from, since H was always saying he didn't have enough business. With W working, H's rages became more frequent and heated, and he would often push her against the wall, the stove, or corner her in the bathroom and yell in her face. He would call her at work constantly, checking up, upsetting her, and making it difficult for her to perform well. H's angry tirades were affecting the children. They are becoming withdrawn and not sleeping well, falling asleep in school and not doing their reading or arithmetic practice sheets. At a back to school night, one teacher took W aside and told her one of the children had talked about H being angry and W crying. The teacher asked if W was all right and did she need help. W denied anything was wrong, which the teacher noted down in her notes of the meeting. So here you have an instance of a denial, sort of statements where the children are saying one thing and W is saying another. So how would you work with that kind of a fact pattern in your representation of your client?
Are we assuming that father has called the teacher as a witness, or had the teacher write a statement?
Yeah, or they might have
denied the domestic violence.
Yeah, or they might have tried to get, you might want to get the notes from school about the children having said, here you want that somebody's made notes perhaps of the children saying that there was this possible domestic violence scene at home, and yet you've got a denial also in those same notes.
Yes, I think that one of the strategies, if the money is available, would be to hire a domestic violence expert who could point to the fact that this is a common trope that we see in intimate partner cases, because obviously the wife does not want to invite the Department of Human Service getting involved, does not want to invite extra scrutiny, because that's going to make her condition more dangerous at home.
Yeah, and I would add to that, particularly when you're before the agency and you're again trying to make a case through documentation, that this is something to build into this, to the same narrative as to why the wife signed a joint tax return with this person. that there are survival choices that somebody needs to make. You, of course, would want to speak in detail with your client about why they told the teacher that, and hear from them their explanation. You don't want to just assume, why somebody was making certain choices. But if it does fall into that very common pattern that Leslie was describing, this isn't that inconsistent with what you're there before the IRS about in the first place. Someone who's trying to keep things calm at home and pick their battles.
Really good points. Yep. Can we go to the next slide? All right. After that, H's rages and swings of anger became worse, and W was afraid he would physically hurt her, or worse, the children. She saw a poster at work about a domestic violence hotline and called it from work. Eventually, she decided to flee, going to a shelter with the children. She felt very frightened about her future and was racked with guilt about having to live in a shelter with children. He kept calling her at work, begging for her to return and promising to cherish her, saying how much he missed her. She finally relented and returned to H. At first, things went well. H even took them on the first vacation they ever had, a real vacation. She wondered where the money for that came from, but soon the rages started again, only they were worse. And then H smacked her really hard in front of the children and also threw them all into the bedroom and locked the door. So now you have issues with the reconciliation, and then what is the impact of the unusual vacation, both on the reason to know, and I would say the equitable, it's inequitable to hold her liable for the joint liability. Anyone want to weigh in on that, about the reconciliation, how you would work about that narrative there?
Well, I think similarly to what Leslie said again on the last slide, was bringing in, trying to educate the IRS, particularly in the administrative proceeding, but also in the judicial proceeding. In the administrative proceeding, you don't have the ability to call witnesses, but you can send in any documents that you want to. So you might be creative about how you contextualize domestic violence, and again, try to educate the IRS examiner or appeals officer on the dynamics and on the common pattern of people taking multiple times before they finally are able to leave somebody who's abusive and in this cycle. And then also what Audrey said, which is really talking it through with your client and incorporating it in their narrative and in your story of the case. You will have to deal with the vacation issue specifically. It's one of the factors is whether you had a significant benefit, whether you went on any. They ask about vacations and big purchases. So again, just contextualizing that and making sure that it's one of the points that you hit in your client's narrative. The fact that W probably had no say in what they did as a family, whether they went on vacation or not, and was not able to really be in control of that.
Yeah. Now, one person in our chat noted that studies show that a victim can leave as many as 7 times before they finally leave for good. And I'll just insert here a question that we got. Sometimes the client can bring in a family member or friend to help in the meetings with the lawyer, and there's a balance between privilege and possibly valuable assistance from the helper. Have any of you all experienced that, and what are your thoughts about that?
I have had clients bring in a family member, and it's a very difficult thing because you don't necessarily know what everyone's background relationship is. I've also had a client who insisted on their spouse coming in to talk about the narrative, and I would not go forward with the interview until I was separated with the client. And then the client expressed relief that the spouse was asked to stay outside. So, family law attorneys deal with that problem all the time. I'm sure Leslie can speak to that. But in our context too, you have to be going through the same types of questions you would as a family law attorney. You know, who is this person really? And is it my client really here of their own volition with that person? So.
Someone else said that asked about being able to suggest the client receiving counseling. I mean, how do you think that's affected? You know, do you think that how would you go about doing that, if at all, in this?
Is the question, should we recommend that clients receive counseling?
Yeah, is that something that you would do? Yeah.
Absolutely. I almost always recommend to every client I have that they receive some counseling. But I'm very, very careful to not use often the words therapy or necessarily even mental health, because oftentimes my clients who are low income individuals do have some hesitations about using those systems or admitting or feel like it could be an admission that they are, crazy or have something wrong with them. So what I always do is I really emphasize how seriously distressing what they're going through is, how if I were in their position, that they would cause all these kinds of like additional effects and trauma, disrupt my sleep. I'd be fixated on it. I'd be scared. I'd be worried. And that all of that is incredibly normal and natural. I stress that as a family law practitioner who hears these stories all the time, that I often pursue my own therapy, and that there's a lot of there's this ability to sort of speed up the healing process and find out who you are outside of the relationship that happens within the therapeutic context, so that you're focusing on this empowerment rather than anything that's pathologizing or making a person feel like they have something wrong with them.
So just to wrap up some of the comments in the chat, Melanie noted sort of, along the same line, arranging for a psych or neuropsych evaluation, and often in the attorney's office, with someone who understands these issues. And that can certainly help. And it can also surface some cognitive or intellectual disabilities and other mental health conditions that may impact judgment. And then there's also the language issue. Is the client limited English proficiency? Do they even understand or much less write at all? I had a case where, the husband forged the client's signature on a consent to assessment. And there we were saying, she doesn't owe this liability. And not only did we have to have handwriting, but we had a test that showed that she had 2% English proficiency comprehension level. Someone else noted that as the further away the last incident of abuse is, then the more memories may come back in greater detail, especially if they're getting counseling. And so sometimes it's good to have more than one interview over time, because you may be able to suss out more details. Okay, let's go to the next slide. So this is just moving our case along. This time, W escaped for good, and with the help of the folks at the shelter. She changed jobs, and with the help of a family law attorney referred by the shelter, she filed for divorce and custody. She did not seek a restraining order because she was afraid of H's fury, and she didn't want him to even have the slightest idea of where she was. All communication was through the attorneys. So now let's go to the next slide. Meanwhile, the IRS audited H&W's joint return, suspecting unreported income from the delivery business. H does not tell W or W's attorney about the audit. He handles everything. The IRS ultimately proposes additional income tax and self-employment tax for 3 tax years. H forges W's signature on the Form 870, consent to assessment. The IRS sends separate notice and demand notices to H and W as they're required by law, but because W is afraid to tell the IRS of her new address and has not yet filed her separate return, the IRS doesn't know her new address. And so the IRS sends W's notice to her old address at H's house. W only learns of the assessment when her paycheck is garnished. The family lawyer, meanwhile, is beginning to negotiate with H's lawyer, proposing that H keep the house if he agrees to pay the tax liability. W's family lawyer also refers W to a colleague who works at a low-income taxpayer clinic to see if she can get the wage levy released. So here we've got the assessment set up and the need to get innocent spouse relief, relief from joint and several liability under 6015. So let's go to the next slide. And, I think, Audrey, you were going to start talking about that, and we can put up the last poll question at the same time. Audrey, do you want to talk about that?
Okay, so we just talked through maybe how an attorney should examine this, and I definitely invite my colleagues to jump in on this too, wherever they see fit. And a lot of these questions that I have here are not things that are answered by our fact pattern. They'd be lines of inquiry to follow once you've got this. And the first is this threshold question of, was there consent to a joint return? Christine definitely touched on this at the very beginning, but if you're going to argue that there was no joint return at all because there was no consent to signing it, that you're actually not in innocent spouse land. You're making what's called a duress argument. So you want to know that up front. Is there even a valid return? And then you would be thinking about, is this B relief or is this C relief? You'd want to ask questions about when your client found out that there was a tax problem, to try and figure out when collections began, to figure out if they're in one of those categories so that you can address those in your application. We've talked about this next one very extensively. Is there documentation of the allegations of abuse? Please do not be put off if there are not, because as many practitioners know who have worked with allegations of domestic violence, a lot of abuse is not documented. On the other hand, if it is, great, get that documentation together, find out about whether there's a tax court case. In this fact pattern, we know there's a family law case. You should be reaching out to see what's going on in there. If the client here, she's got an attorney, see if you can talk to the attorney, get a copy of the file, find out what's in there. We know that this client had some income. She was cutting hair. We don't know if she was an employee or an independent contractor. So we'd want to know, did she have her finances together? Was her income reported right? If not, why? Oh, and actually another point too, this last one about getting in touch with the family law attorney. We didn't talk about this earlier, but you want to also make sure that things that you're raising in your innocent spouse case, especially if it ultimately ends up in the tax court, which is public, doesn't damage the family law case. This is a two-way street, right? Your client wants to do well in both of these. So you might want to know, like, are we submitting something in our tax court case that is totally inconsistent with something that's being argued in the family court, or is going to come back to hurt you in the family court? So those are just some threshold thoughts. The next slide, please.
Oh, can I add one thing there?
Yeah.
Actually, we'll get there with the 7-factor test. Sorry, I'll hold my thought.
All right, yeah, please do jump in anytime. This is a discussion for all of us here. So, as we said earlier, even if you think the client is qualified for B and C relief, you still want to set up your case around the F-factor test. So we look at marital status. Okay, this is a 7-year marriage. So she has filed for divorce. So we would argue that that factor would be in her favor. Something to keep in mind. Remember, this is not supposed to be treated as just checklists, but in practice, some of the IRS examiners will treat all of this as checklists and say, all right, marital status is positive, but then use marital status against your client later when they're out, when they're evaluating abuse and the knowledge factor. I have had that happen. We talked, going back to the question that was presented in the fact pattern about inconsistent statements and then reconciliation. Again, people that work with survivors of abuse are very familiar with the concept of reconciliation. People don't leave the relationship sometimes for years and years and years. That is not obvious to some people that do work in both the examiner and the appeals level at the IRS. It's not going to be taken for granted. I've seen that not only through verbal statements in some of these hearings, but through the written reports evaluating cases after, okay, where the fact that someone didn't leave the relationship was weighed against them. So you want to make a strong case really trying to educate for the file about why your client stayed. So then even if you cannot convince the individual officers or examiners that you're working with at the agency, you have a foundation for when you go into the tax court to call an expert witness on this. So make those arguments, back it up with studies if you have to, send in copies of articles, whatever you need to do so that you're not precluded later from raising that in a forum where you can have an expert witness and you can have your client testify in person. All right, next, economic hardship. Again, these are just some sample questions. I mean, these are the types of things you'd want to know. Is in our fact pattern here, we know there's an open divorce case. Has temporary custody been granted? Is our client right now the primary care giver for some dependents? How much is she making cutting hair? Is she still cutting hair? And are there any other sources of support? Is there child support offsetting some of the finances that she needs to set aside for the kids? Are there family members giving money? We want to know all of this. The IRS does look at the administrative level, looks very carefully at your financial statements. So you don't want to fill those out lightly. You want to be honest, because if your client is pegged early on as lying about their finances, it's going to make everything else difficult to prove. Jumping down now to knowledge or reason to know. This is now where we, where we really have to flesh out our story. We know that husband had his own business. That's the typical scenario we often see in innocent spouse. If one person has their own independent business that their spouse isn't involved in, one of the arguments is how are they supposed to know about the books and record keeping in that business? And of course, if there's emotional and physical violence, is it not just, is there physical violence that makes it hard to question the tax return? Is there abuse or violence that makes it hard to question just the business and daily life? If you say, hi, you came home from work, how was your day? Is that going to set the spouse off? Or if you say, how many widgets did you sell today? Is that going to cause a problem? So we get the next slide, please. Legal obligation. Again, the question to ask here in our fact pattern. We know there is a family court case. Again, we know it's not concluded, which means there might not be a final separation agreement. So we don't know what the disposition was on past tax debts or other debts. Most divorce agreements will include a section on what to do about debts and liabilities and a subsection on taxes. So we need to know that, because if there is a legal obligation in the family court, that is a positive factor for your client. If a court has ruled that the other side is going to pay, even though it is not, again, binding on the IRS, it is an important thing to add here. Significant benefit factor. We talked about it in the fact pattern as being part of knowledge, but this vacation that the person went on, but it also speaks to the significant benefit. As Christine said, we're going to need to know a lot about that. Okay, is this an extremely expensive vacation? Is this something that should tip somebody off that something is wrong with the finances, and an unusual vacation that they benefited from? We're also going to want to talk to the client about her compliance with income tax laws. So we don't know what time of year they are in this fact pattern, and we don't know where they are relative to the divorce case, but in a lot of ongoing divorces, there'll be some temporary provision as to whether the parties are going to agree to file a final joint return or not for the last tax year. So we want to know that, or we want to know if she filed separately, and if she did she do it correctly? And of course, with the mental and physical health factor, we don't have a lot of detail here, but we know that she could be somebody that maybe has a diagnosis of PTSD. She could have other mental health issues, whether as a consequence of the violence or otherwise. So I'm sorry, Christine, did you want to jump in with your comments on the F factor test? So.
Well, I think you covered it. legal obligation is just another point of coordination with the family law attorney or with your client, even suggesting some I've had clients who've been reluctant to even ask for that to be included in the divorce agreement. But it is sort of a process of letting your client and their family law attorney, if they have one, know what the law is on the IRS side, and let them know that the family court order regarding taxes is enforceable in the family court. It's not binding on the IRS, but if, as you said, Audrey, if the court has ordered H in this case to be responsible for the joint tax debt, then that will be a positive factor for W when she requests innocent spouse relief. So it is just a conversation that you have to have probably multiple times with your client and their divorce attorney, which hopefully they have. Compliance with income tax laws, that's one that you're probably going to be returning to your client yearly to talk about and making sure that they file on time every year going forward. If your client is self-employed, you've got to talk to them about estimated tax payments and making sure that they do not have a liability every year that they can't pay. So really getting them set up with good record keeping so that they get that positive factor on their side when the IRS makes its decision.
So if I may, if we can move to the next slide for just a minute, so we're working on time. Just to wrap up and raise a final issue here, this is after the LITC attorney files Form 8857. The IRS is required to send H a notice as the non-requesting spouse that W is seeking relief from joint and several liability, because if W does get relief, H is going to be on the hook solely for that additional liability. So H writes in and he challenges granting such relief and submits the consent to assessment with W's signature, along with several statements she made in depositions during the custody portion of the family law event, in which she minimized H's threatening behavior and H also points out that she never sought a restraining order as evidence that he never harmed her. So how would you all handle these inconsistent statements at that level?
I think you definitely have to address the fact that—
Leslie, we need you to speak clearer with a higher volume.
Sorry about that. Can you hear me now?
Nope.
Interesting.
How about now?
Perfect.
Okay. So I think that it's going to be really problematic if you have depositions where wife was motivated to sort of hide the domestic violence dynamic during a custody dispute, because that would normally be a time where someone has a motivation to play up that angle in order to get a higher amount of custodial time. But what I would say is that there's an angle in almost every state's custody statute, which is that parents who are friendly parents to the other parent, right? So people who are showing that they are willing to forgive and move on and co-parent, that under the factors can be rewarded. So sort of showing that her motivation there was actually to bring harmony and to make her case that's in a way that's in line with what the custody factors are in her state, and not because she actually did hold this responsibility, but that rather she was attempting to co-parent.
And I would also think that, the absence of filing a restraining order, that's where, your expert, even though you can't call an expert witness here, but you can submit, studies and things showing that X percent of cases, there is no restraining order partly out of fear.
And I would just add to that too. And Leslie was just talking about how some states have specific statutory provisions like that. Know your state and know what relief is available and know how things work, because you're going to have to explain that to the IRS. In some states, restraining orders are easy to get. In other states, they're very difficult to get, and they're not going to come until there's an actual trial or a trial-like proceeding. So the examiner or the appeals officer or the tax court judge is not going to know how it works in your state. It's your job to really be able to explain that and use that to help explain why your client did or didn't do, seek a certain legal relief.
Mhm. You have anything else to suggest, Christine?
Well, in these cases, I always try to brainstorm with my client what evidence might exist that will help corroborate their story. And so sometimes there are people that they contemporaneously confided in. It's very helpful if that person is somebody that the IRS will automatically trust. We got a statement from a pastor once, which was extremely successful, but even friends, people who are willing to sort of contemporaneously corroborate what was going on in your client's life at key points. And maybe sometimes those third parties can actually remember details that your client may not have told you. And so that can be extremely helpful. You have sort of a different perspective on an incident, and sometimes that perspective is extremely helpful if your client has been sort of minimizing or sometimes it's difficult to pull those details out. So I've had success with contemporaneous accounts from children who are now adults, for example, which is tricky, but sometimes a 20-year-old, for example, has written extremely compelling statements, friends, pastors. So I think that's a good way to deal with inconsistent statements, is to try to find any contemporaneous tie-ins that you can.
It's really helpful. So let's go to the next slide. And this is really the slide that's going to wrap up this stage of the case and then set up part 3, which is that the IRS ultimately denies W relief from joint and several liability, determining that she had actual knowledge that the income was greater than what was reported because she knew her husband was using drugs and he took her on an unusual vacation. 2, that she could not benefit from turning a blind eye to what was reported on the return by not asking questions before signing. 3, she benefited from the unreported income, the unusual vacation. And 4, her husband's behavior did not rise to the abuse such that it would excuse her not inquiring further into the financial matters. So I'll answer the own question about what is next. I mean, then you've got the issue of, do you file a petition in tax court? And to frame it all, why we've been talking so much about getting corroborative statements is that you are going to have to deal with 6015H, which is saying that the court has to rely on the administrative record, namely what was submitted to the IRS in making its determination and reviewing the innocent spouse determination. And we're going to talk a lot about that in our part 3 and how you deal with the state of the administrative record when you get a client who you haven't been representing at the administrative stage, or when what you've been trying to do here is build the administrative record through the administrative stage. So stay tuned for part 3. And we'll just go to the last slide so you can all get the information about the guide and the discount code for 20% off. It's available just through April 30th. And then there's the link to the video, and then links to various support information. And while people are copying that down, Christine or Audrey or Leslie, do you have anything more you want to say in conclusion? And I'm particularly grateful to you all for doing this incredibly informative program. Anything you want to say in closing?
I think it all comes down to empowering your client and telling their story. So I hope that people will feel comfortable using these resources to dive in and take a few cases, and it can make a huge difference in people's lives.
You can sign up for the LITC Connect Pro Bono network on the LITC Support Center.org. That will give you in the mix for taking cases pretty much from anywhere in the United States, from any LITC. And for that, I think I'll just thank all of the panelists, as I just think you've just done an amazing job. And I just want to remind everybody that for continuing legal education, you should expect an email from the ABA within 48 hours. I know some folks say that they haven't gotten it, so we'll look into that for the part 1. And again, this recording will be up on the ABA website, and as well as the materials, and also on the LITC Support Center website. So thank you all for coming, and be sure to get this fabulous book by Christine and Audrey. They've done a terrific job. Okay, thank you so much. And Meg says you can email her email's in the chat about the CLE certificates. So long.